when there are multiple crimes involving multiple victims, the law is that the total impact of singular offenses against different victims will generally exceed the total impact on a single victim. We don't have that here. We have a single victim. But first, not to impose a consecutive sentence for the endangering would be to make that endangering offense a free crime. And one need only view the circumstances of the offense and the video to know it shouldn't be a free crime. The crimes are somewhat interrelated. They're not completely independent of each other, but they are predominantly independent of each other. Corey was subjected to an awful time on the treadmill that I've described. It was brutal to watch that treadmill video because you rarely see a child essentially inflict harm on himself in the beginning until his father starts to put him back on it. So it doesn't take a vivid imagination to consider the fear Corey's in at that point. The two incidents are approximately 12 or 13 days apart, although they both occur in Barnegat. They're at different times, and they are at separate places, although relatively close together, the gym at the complex and the defendant's apartment at the complex. But they're not so sufficiently close in time as to be a single episode of aberrant behavior. This is not someone that went and committed 4 car burglaries in a parking lot, one after another, which would be a single episode of aberrant behavior. They clearly involved separate acts of violence and or threats of violence and harm to Corey. The second act being the ultimate act, which was successful in ending his life. They don't involve multiple victims. So I conclude, for those reasons, that it would be to send a message to the public, to the defendant, and to those who abuse children, that you can get away with one offense if you get caught on the other. And that's simply inappropriate for deterrent reasons in general or for specific deterrence in this case. And therefore I conclude that count 1 and 2 should be consecutive. The law requires me to make an additional statement on the overall fairness of a consecutive sentence. This is a requirement imposed by our Supreme Court in State v. Torres, 246, New Jersey, at page 246, a 2021 case, where our court held that the trial judges to make an explicit statement of fairness that explains the overall fairness of the consecutive sentence. So first, I've imposed sentence on the second-degree crime at the bottom of the second-degree range. Second-degree range is 5 years to 10 years. I conclude that if I were to go greater than the bottom of the second-degree range, I would be subject to an abuse of discretion as that being excessive. Secondly, the endangering sentence is not part of the No Early Release Act. It does not contain a court-imposed period of parole and eligibility. It's referred to as a flat sentence. Additionally, I conclude that the consecutive sentence is fair because of the reasons I just articulated about no free crimes. Defendant is 32 years of age. Absent some unusual medical event for a young person, he will eventually be released to his own liberty. He will eventually be a free man to walk around. Corey, of course, will not. So this is not the functional equivalent of a life sentence, despite the imposition of a consecutive sentence. It's also fair and just, given some of the testimony by Dr. Andrew, who testified in great detail about this, got down off the witness stand, went to the large screen TV and pointed out the bruising all over Corey's body, and testified about the injuries and bruising of different ages in different levels of healing, demonstrating the doctor's concern about ongoing abuse. We had pretrial hearings about this. The state, in count 1, endangering, originally alleged abuse was occurring from December of 2020 through March of 2021 up through the date of Corey's death. I concluded that, really to protect the defendant's right to a fair trial, I concluded that many of the other incidents were attributed to normal childhood activities. Going hiking and getting a branch that comes back from a shrub into the tree, playing sports. And because there was what I found to be insufficient medical documentation or medical testimony that those incidents were attributed to abuse, I did not allow them in. But Dr. Andrew, who did not testify in that pretrial hearing but testified later, was very compelling about those levels of injury and their different states of healing. Kids get bumps and bruises. Corey had more than bumps and bruises that you would see on a 6-year-old. So for all the foregoing reasons, I conclude the imposition of a consecutive sentence is overall fair under the circumstances of this case. The state's taken an additional position that I should impose the least restrictive or flat prison sentence first, such that it precedes the more restrictive prison sentence, meaning that the defendant should serve the endangering sentence before the aggravated manslaughter sentence. There's a very difficult legal analysis associated with that. I rely upon State versus Ellis. It's an appellate division case from 2002, 346 New Jersey Super 583. And a Supreme Court opinion in State versus Pierce, P-I-E-R-C-E, 220 New Jersey 205, an Supreme Court decision from 2014. It is legally possible. In fact, what the Ellis case says is, while it's not illegal, it's difficult to justify. And it typically runs afoul of certain sentencing guidelines, and it may interfere with the expertise of the parole board in determining when a defendant should be released on parole. And based upon both of those decisions, I conclude that I cannot impose the least restrictive sentence first without engaging in an abuse of discretion. So therefore, I direct that the No Early Release Act sentence on the aggravated manslaughter count run first, followed by the flat sentence on the endangering count, such that the aggregate sentence is 25 years and that the jail credit of 885 days comes off the aggregate sentence. Another condition of the No Early Release Act is that defendant shall serve a 5-year period of parole supervision upon release, that he shall provide a DNA sample and pay for the cost the same. There are 2 $50 victim of crime compensation assessments, 2 $75 safe neighborhood assessments, 1 $30 law enforcement training and equipment fee. The superintendent of the institution where defendant is incarcerated shall draw sufficient monies in an amount not to exceed 1/3 of the inmate's total income as may be required to pay these assessments. The Office of the Victim of Crime Compensation Board submitted a request for restitution for funeral expenses. There's been testimony during the course of the case about whether or not defendant's parents paid for funeral expenses, whether or not the Ms. Michelot's family paid for them through the VCCO office. I've considered, am I supposed to hold a hearing on that? And I conclude that the parties need closure in this matter. They don't need another hearing on whether or not those expenses actually went to the funeral, or and the VCCO letters also refers to some other expenses not associated with the funeral that may not be directly attributable to defendant's conduct. If these were out-of-pocket expenses by anyone qualifying as the victim, I'd be inclined to consider them further. The Office of the Victim of Crime Compensation Board exists for the benefit of victims. It charges, the defendants are assessed, like this defendant's been assessed, 2 penalties for that, to fund that, and I conclude at this point that it's not appropriate to order that restitution because of the questions concerning who paid for the funeral, and more importantly, I would have to do an analysis of the defendant's ability to pay now or in the future. He's been incarcerated for the last 885 days. He's been unemployed. He clearly has no ability to pay now, and he has little ability to pay for the next 25 years. So I conclude, for those reasons, that mitigating factor 6 is not present There's no restitution to be paid, no ability to pay restitution, therefore I do not order restitution. If there's any bail in this matter, it's discharged. There are no dismissals. Madam Clerk, is there anything else I need to address? And Mr. Gallucci, we get his appeal rights form? All right. Anything further from counsel?
No,
All
Judge,
right.
thank you.
Thank you, everyone, for your excellent presentations. That concludes the matter.
Thank you.
All right.
Wait, do not exit yet. The back row is going to exit first.